Hello everyone and welcome to this Legal 500 webinar sponsored by Lydian, Conducting Effective Internal Investigations, a practical guide for in-house lawyers. My name is Joe Boswell. I am a senior member of the Legal 500's in-house legal research team, and I'll be introducing today's session. We're taking a deep dive into internal investigations today with a mix of both practical advice and technical knowledge set to be dispensed during the next hour that will help in-house counsel of all experience levels tackle this complex issue. The webinar will be structured around four main topics, each introduced by one of our panelists. The topics are in order: when to conduct an internal investigation, getting the ball rolling, conducting the investigation, and further actions. Before we get started, I'd like to quickly remind the audience that the opinions expressed are those of the individuals only and do not necessarily reflect those of the organisations they're a part of. And now I'll spend a couple of minutes introducing our fantastic speakers. Jan Hofkens is a partner at Lydian, whose wide range of experience sees him regularly consulted in cases of employee fraud, privacy issues related to internal investigations, whistleblowing, and dismissal for cause. Yves Lenders is a partner in Lydian's commercial and litigation practice, where he heads the ports and logistics team and regularly advises national and international clients on complex construction litigation matters, as well as post-acquisition litigation work and shareholder disputes. Fatima Keskin is Vice President Legal, Ethics and Compliance at Ahold Delhaize, a highly experienced general counsel. From 2012 to 2017, she served as the president of the practice group of international company lawyers at the Belgian Institution for Company Lawyers. And last but not least, Michael Rea is general counsel of Eurofin's scientific group and an in-house and private practice lawyer with over 15 years of experience. Prior to joining Eurofins, Michael has been working in-house in the fashion industry at CBR Fashion Group and in the e-commerce sector, where he helped build and IPO the German startup Windeln.de. So with the introductions out of the way, I'd like to throw over to Michael now to begin the first topic, which is when to conduct an internal investigation.
Yeah, thanks a lot, Joe. Hello, everybody. And first of all, apologies that I'm all black. And this is not some new privacy gadget that I implemented, but just some technical issues that for whatever reasons, you probably hopefully can hear me, but you can't see me. We tried, but you have to tolerate me without picture. So starting off on our tour is the question, when to open an investigation? The answer looks in the beginning quite straightforward. As soon as you have become aware of sufficient facts constituting a serious breach or a serious misconduct, you should start opening an investigation. I will quickly cover the three most relevant topics that I see when it comes to the question when to open, which are in the order that I will be covering them. How to become aware of a breach. And the second part is what is actually a relevant breach or a relevant misconduct. So what's the scope that you should be looking at? And the third part, when do you have sufficient facts and what to do then? So that's mostly covering the stage between when you get the notification in the first place and when you actually start your internal investigation. So starting with how to become aware. Becoming aware goes via two different channels. I call them the formalized channel, which is the classic whistleblowing hotline, whistleblowing channel, however you call them, and something that most companies tend to have these days. And then you have the non-formalized channels. And before I go into the whistleblowing hotline with a couple of details there, I'd like to spend a few words on the non-formalized channels, because from my practical experience, those are equally important as the formalized channels. And if I look into what throughout my career I've been getting in terms of notifications and reports and hints of misbehavior, often these were not initially coming through any formalized whistleblowing channel, but they were brought to me by colleagues, by the relevant function that are also dealing with potential or that have a likelihood of detecting misbehavior, such as internal audit, controlling HR, You can get them from competitors, from suppliers, from customers, so from everywhere. So it's important to keep an open eye and open ear, and not only to stare at whatever will pop into your whistleblowing mailbox, because then you might be missing some of the very relevant things. Practically speaking, from my experience, the informal notifications are less frequent, but usually they're more substantiated. So the likelihood that actually something relevant behind what people tell you, and they often will tell you in confidence, is quite high. One practical thing when you get these "I tell you in confidence," so people come to you, if they tell you in confidence, this is putting you in a bit of a dilemma, because you know something which is relevant from your professional perspective. You should bring that somehow into the normal processes, but having that in confidence binds your hands. So difficult to handle. I think what I try to do there, and what usually works, you have to tell the people, look, here's the formalized channel, and I come to that in a second. The formalized channel also allows anonymous notification. So can you please also report that into the anonymous channel, in the formal channel, because then we can start something without revealing your identity. If that doesn't work, well, then it's kind of a judgment call, whether you rather breach the confidence out of your obligation towards the company, or whether you kind of keep that secret for you, and you see whether, and you hope that it's coming up somewhere else. Now, looking into the more formalized channels, so whistleblowing hotline, whistleblowing point of contact, how we're calling that, there's quite a bit to say on it, so I won't cover it all, but I rather will focus on a couple of practical aspects to consider when you're setting that up. First question, what's the scope? Do you open that to only your internal employees and internal complainants, or do you open that to the whole world? I see a tendency going to the second thing, even though I think the most relevant things are usually coming from the inside. So you probably don't lose a lot if you close it down to the general public. The next part, I already mentioned that, anonymous versus non-anonymous reporting. I think in the past, this was a bit more of a discussion. Nowadays, with the EU whistleblowing directive upcoming, which requires some sort of anonymous reporting, and also looking at the French legislation in Sapin 2, probably you don't really have an option any longer to not also allow anonymous reporting, even though from a practical perspective, I wouldn't overrate the importance of having anonymous reporting. It's kind of important to have it in the first stage because it lowers the threshold to report something. But the more you go into the facts, the more you go into the case, the harder it will be to really maintain the confidentiality and the anonymity of the whistleblower, because at some point in time, you may need the person to act as a witness, or you may need the persons to go out in the open. So I think it's important to have it in the beginning. Later down the road, not that relevant, because if the people still later on in the process insist of being kept anonymous, you may run into a dead end. So anonymous reporting versus non-anonymous reporting. The next part, very important, irrespective of how you set it up, you need to have a person in charge of that, or a team, or an outside supplier, or someone. So these whistleblowing hotlines need to be monitored continuously with a high frequency, because you can't afford that you have some really interesting notification sitting in there, and it takes you a week until you finally find it, and another week to respond it. That's not what it should be. So you have to kind of commit yourself to answering there very quickly and to monitoring that constantly, because otherwise you defeat the purpose of that instrument. An important practical aspect is language. So already here in Belgium, if you want to offer to have that in all possible languages in this lovely country, then you're already up to 3 official languages and one kind of lingua franca being English. So you're already up to 4. And depending on how international your company is and how international your business is, you have many more languages. However, practically speaking, you should allow the people to notify in their native tongue or in the tongue of the country, because otherwise you may deter them from notifying. You have to then find people who are either capable of dealing with those languages, so spreading the monitoring team internationally, or you have to bring in some translation capabilities. The first line thing is quite simple. Use some Google Translate or something to kind of get a very first glimpse of what you're doing. It's a bit of a borderline advice because we don't know where Google Translate is actually going. So among lawyers, GDPR-wise, I might not be totally on the safe side, but from a practical perspective, I still think it's useful. And later on, you need a translation agency that is capable of handling a big bunch of languages in a reasonable response time. And now coming to the last point on becoming aware, your employees also need to be aware that you have this thing. If you have a very nice channel sitting out there and nobody knows, it's worthless. So think about promoting this channel somehow, make it easily accessible on the internet. What we've been doing, this whistleblowing hotline on our system is integrated in the code of conduct, and we have a code of conduct electronic training where all our employees worldwide need to go through on a yearly basis. And therefore we kind of make sure that people are at least vaguely aware that there is something, and if they're in the situation where they discover something that could be relevant, they will remember, they will try to find, and then hopefully they would find it. If you receive something in there, in your channel, I already touched on that, confirm that you got it. And this is also a good point in time to directly in this first confirmation email to include your policy on non-retaliation in order to assure the whistleblower that he or she does so at no personal risk if it's an honest reporting. So now coming to the second part, what is an actual misconduct that you should cover there? And I think here there's no easy one-size-fits-all answer, but there's a couple of things to bear in mind. And most important for me to bear in mind is that whistleblowing and internal investigations is kind of the last resort. It's a very exceptional process, and you should structure it in a way that it's an exception that only kicks in if the normal processes do not catch it anymore. And depending on in which environment you're working in, which industry you have, which company culture you have, there might be different things where you need to draw the line between the standard processes and the whistleblowing internal investigations process. A typical thing that comes up is employment law. There's on promotions, demotions, dismissals, there's a lot of conflict potential, which people often try to shoot into whistleblowing channels. And on this, for example, in our company, we have a pretty straight line that we try to put everything back into the regular HR channels, because that's what labor law is good for, to deal with unfair dismissal or not. That's a labor law question. That's not an internal investigation question, unless you find certain instances and certain aspects that indicate that this is just kind of the tip of the iceberg and that there's a structural problem behind that. In that case, you may directly pull that into internal investigations. But if this looks like a clear cut, somebody was fired and is unhappy about that, refer them to the standard channels. And now we're coming to the probably most important and most difficult thing, when to open an investigation. A typical reporting, a little bit exaggerated, but what we usually get is something like, hello, I'm working in your laboratory in Antwerp. There's sexual discrimination ongoing in our lab, and this may hurt your reputation. You're sincerely anonymous. Well, so now I'm there having something which is on the face of it, it could be everything. It could be hinting me to a very bad scheme of discrimination, of macho culture, of whatever, Or it could be just somebody who was frustrated for whatever and needs to vent it off. And from looking at that through the eyes of a lawyer, it's neither substantiated nor is there any evidence. So this brings us to a very important thing, and that's quite typical. I mean, I'm making it a bit more plastic, but I hardly get notifications that are in the first stage usable to kind of base the decision whether I want to go into further investigations, yes or no. So I need this pre-investigation stage there. And here, a couple of things from a practical perspective that are important. So whoever is monitoring that, whoever is driving your whistleblowing channel, should have the mandate to investigate a little bit further and to go back to Mr. or Mrs. Anonymous and ask them a couple of questions and ask them to detail a little bit more, so that you will be in a position to get something which is precise, at least in the rough outlines, and which is going beyond mere keywords like we're having here. And so here, that's why on our side we set up a list of rules and a procedure how to deal with that in the first instance, which is detailing a little bit what would be our standard approach, what kind of questions we would typically ask, how we would approach the persons to get more flesh to the bone. In this stage, if you're on something which could be very serious and damaging, so if you see from the original notification that this could be something very critical, this might be the time to give additional reassurance to the whistleblower that goes beyond what you have in your normal policies. And you may want to issue some sort of comfort letter, security letter to them to keep them cooperative and to protect them in the further stage of the process against all sort of retaliation, dismissal, but also hold them harmless of personal litigation costs if they're attacked for their whistleblowing. So that's something that you may, in critical, and these are the interesting cases, want to issue. And so now, if you look at statistics, what is very important to do, you need to have a clear procedure how you stop any notifications where you see no substance behind it. Because from my experience, if you're even taking away all the spam and all the nonsense that you get into your whistleblowing channel, 2 out of 3 reports that could possibly be something die off in the first couple of weeks, because usually the anonymous reporters don't get back to you or they fail to substantiate. So what we've put into our policy is like a number of instances. How often do you have to ask? How long do you have to wait if they're not responding, so that you can also close the case? Because otherwise you get stuck with tons of open cases where there's no movement, and this is a bit frustrating and spoiling your kind of case statistics as well. And for those instances where you have substantiated evidence that there is a problem there, you should take some formalized decision now to open the investigation, and you can do that within your legal compliance department. We set up kind of a small investigation case board where we have legal, HR, and someone from the business in there, and based on the findings of our pre-assessment, we then take the decision to open or not open in final a real investigation. And on what you have to do there and what you need to do there, Fatma will give you more details. That's it from my side. Thanks a lot.
Thanks a lot for that, Michael. I think it's actually time for us to move on to our second topic, which is going to be introduced by Fatma Keskin, and that is getting the ball rolling.
Thanks a lot, Joe, and thanks a lot, Michael, for sharing your experience with us. As an introduction, as an in-house counsel, I have been involved myself in various settings in investigations. So before joining Deleuze, Luxembourg and Belgium recently, I served as head of legal and compliance of a subsidiary of Panasonic. And before that, I was for Europe chief compliance officer with international papers. So you see, as an in-house counsel, I've had the chance to be in various settings into different kinds of investigations. So, and I see also in the attendees that there are various amounts of both, lawyers and in-house counsel. So if there are questions, please also, let's try to make it interactive where possible. But indeed, determining the scope and getting the ball rolling is not an easy thing, because it depends so much on what issue you have to deal with, right? So let's assume that so through the variety of channels that my colleague Michael just has introduced, you already actually decided, okay, these facts, these allegations put you in a position that you have to start an internal investigation. So at least maybe a short one, depending on the facts. But determining the scope, getting the ball rolling, depends so much on the facts that are available to you and the credibility of the channel that brought in the complaints or the allegations, because you have so many channels, not only the whistleblowing, but it's sometimes authorities or internal audit that has brought something to your attention. But if you look at the big categories of potential investigations in-house counsel are confronted with, you have the categories that are, I call them a bit more straightforward, right? It's fraud, embezzlement, even antitrust and anti-corruption, so more on the financial impact on a company, because it's really, you know what you will be looking for, whilst you have the other like grayer areas like in HR issues, harassment issues, Me Too cases. These are really even, those are even more emotional and less factual sometimes, and more difficult to getting organized as an investigator. But key principles, I think, what I, both in the teams I work with or with the outside counsels I work with, it's so vital in doing investigations that you work around, that you at least have a policy of doing investigations, that you really explain it also within your organization, that you somehow socialize this, because it's not only the trust, the objectivity, the accurateness that you have to, warrant the whole time, but it's, the speed is also quite important. Right? So speed, trust, doing an objective investigation, because, it's the reputation of some people that might be at hand. So it's not an easy thing. You don't have like 6 months or 9 months to take it at ease, right? So those principles are quite important, and hopefully, I think, most of the companies that I, the lawyers that I spoke with from this circle, and more companies have also investigation policies and try to socialize them. It's a paper somewhere, and did you really take the time to socialize it before your investigation kicks in? Because I think those principles are very important, and determining the scope depends a lot on the facts you have and the quality of the facts. You're a lucky investigator if it's already straightforward into your hand. So I think that's quite important, that you have the facts right, but also you can't just determine the scope and that's it. That's what we're going to investigate, straightforward. No, that's not how it works in a normal, in a realistic work, because the scope of your investigation is changing. The more you learn, the more the scope of your investigation can change. So and it could also be that after a couple of weeks that you decided, like, all of the allegations we have, that you can also quickly decide that actually that things are really not in reality as they appeared in the beginning, that you actually can close the investigation. But I think determining the scope will help you in getting, having, when you go to the next steps of your process, because you have to set up a team and have the right people around the table and give them really specific tasks. And we could maybe use a couple of examples if you think about more into the areas of like an antitrust or an anti-corruption investigation, or you have some theft going on. in setting up the team, because it's quite important that you have the right people around the table, and I'm going to name a couple that I would tend to use. It's think about most often you have certainly a lawyer, not only just you have a team lead in the investigation, but also a lawyer for legal privilege in-house where possible, of course, your in-house counsel, and depending on the case, you have an HR lawyer or maybe more of another expert. The data protection expert. I cannot imagine many investigations anymore that you don't have your data protection expert around the table. In some cases, it might be really good that you have either you have it in-house if you have that possibility, either you work with a supplier, a forensics team, certainly in some antitrust matters, or there is an authority involved. If there's an authority involved, I would really recommend it, because then, well, you don't know what the authority is looking for. So you would be in a strong position if you have also some forensics expertise around the table. But that also means that you have to do your homework, of course, in advance, and that you have done your that you have a pre-arrangements with a forensic expert, because the moment that you are confronted with facts, you have to start an investigation, leading that entire effort, then looking for certainly a supplier, and then arranging a data protection agreement with that supplier. So I would really, that's in depending on the size of your company, I think it would be good if you pre-identified a certain supplier that you can do some forensic investigations with, because it's if you then need 3 or 4 weeks of company bureaucratics, that doesn't really help you into the process. Certainly if there is a fastness and a speed that you need in some data that you need to retrieve. So I think forensics, you don't need it often, but I would really, advise, that you could consider it in some particular scopes. Data protection, I already mentioned, and certainly depending on the case, a loss prevention expert, asset protection, if you have those in your company. So now I'm in the luxury position in retail. You often have very good asset protection and loss prevention experts in your organization. And depending on the case, depending on really where you need a legal privilege, outside counsel might not be a luxury. You might really need it. It might help you. Well, where you need legal privilege, you really don't have so much of a choice. But in some cases where above there is a time constraint, or you have the volume of work is a lot, but also if it's a very emotional case with you might have, as an in-house counsel, sometimes even a conflict of interest. Certainly if it's an HR or harassment case, it might be worthwhile at least to outsource a part of the work, like doing some of the interviews, so that you can never, sort of the objectiveness of the investigation can never be challenged. So these are just a couple of ideas in setting up the team, but quite important. Not only you have to have the right people around the table with the right expertise. If you don't have it in-house, look for it outside, but make sure that you have pre-identified them in advance, but also have the people around the table who have some kind of decision authority, or really know their field very well, and don't have to constantly, that you don't lose time in that process. That's quite important, because that's in some cases it might even be like a crisis management situation, whereby I think each investigation really needs to have a very clear, like, who is in the lead, who's in support, and that role, and discuss that role, make it clear to the team, like, okay, who is even going to set up all of the teams, the team meetings or the Zoom meetings, whatever, that you really make that clear, like what the expectations are, what the role is of everybody in that team. Also deciding on next steps. So there are roles and next steps that will be important for, like, in the investigations, the fact gathering or other stuff that the different experts, or an advice on data protection that you need, etc. I think the clear role of the team member should certainly be made clear, but also, for in-house counsel, we have to play with a lot of balls in the air, and in the meantime, whilst you do your investigation, you have stakeholders to manage. You have your stakeholders to manage, and make sure that you really align, like, okay, who is going to communicate to your CEO, to your executive committee, but also there is somehow, there is a subject, there is somebody who complained. You have if it's a people's issue, there's somebody who claims, but there's also somebody who has maybe a sort of claim against the person. So you have to also make sure that in all objectivity and with trust, that you respecting the confidentiality, etc., that you also keep a communication line open to those individuals, like also Michael mentioned. So you have that. Those roles are quite important, like in the, you know, what is the role of a certain expert in that group, who is doing what, who is doing the communication. But in that communication part, don't forget, you have your authorities, a data protection authority of some other kinds of authority. And also, if facts are changing during the investigation, that's about controlling the investigation, make it very clear what kind of facts. Imagine that you have your, the team that I didn't mention is the ESO or the CISOs, the Chief Information Security members. Most people also have, like, you know, if you have IT and digital incidents, you need those experts around the table, so that you make it very clear, like everybody does the agreed stuff. But if some assumptions change, because as the investigation is unfolding, you learn so much new things. It's quite important that you make it very clear, like when do people have to come back urgently? When do you need another unplanned crisis call, etc. I think those are the things that I really wanted to share, Joe, with the team on, like determining the scope, setting up the team, and choosing the law firms. It's more that's a not only a personal job, it really depends on the need that you have as an organization, depending on the scope. So, and controlling the investigation is really, I think, is the task of either it's the head of compliance, sometimes the crisis manager, but as long as it's controlled and it's made clear that it's not like everybody in that team. So that was a couple of the things that I wanted to share. I don't know whether there are questions or we move to the next topic.
Thanks a lot, Fatma. I was wondering if either Jan or Michael might like to ask a couple of questions. So I don't know if either of you would like to go ahead. I know Michael's got a lot of experience of in-house investigations.
Well, if I may add one aspect that probably Jan and Yves will not be so pleased about, but which is quite crucial from my perspective and from some bad experiences I made in that respect in the past. Even though those internal investigations tend to be a very dynamic field, which come along with a lot of surprises, when you're involving outside counsel, you have to try to get some control over their scope, what they're doing, and the budgets. Because in one case in the past, what I did, I was kind of one of my first things, and I was exposed to quite critical thing, and I was like, okay, well, so open everything, get whatever support you want, and that worked nicely. So we kind of got the thing under control, but what spiraled a little bit out of control was the budget of the law firms and the other advisors that we had in there. So I think what's crucial, try to think in stages, try to structure that in certain steps and agree on budgets or milestones or whatever, so that you in the middle of your investigation, and we as lawyers kind of tend to then focus very much on the facts, but that you don't lose track of your administrative responsibilities, which is also making good use of the company's funds. Because ultimately, if you are able to clean out this investigation properly and you leave a huge bill, people will not be grateful for your good job on the investigation, but they will start shouting at you for the huge bill. So that's kind of a practical advice, and I guess that Jan and Yves can kind of offer solutions on how to manage that properly.
Well, Michael, if I may, Jan Hofkens here, maybe a short introduction. I'm an employment lawyer, so at Lydian, and in that capacity, often involved in investigations, and I'm working often alongside the typical Big Four forensic accounting teams. So I also know how they react, and I know from experience that indeed budget control is an important topic. And as always, when you deal with lawyers or external counsel, it's all about making good agreements from the start. That's about it, and reporting from time to time on how much time you spent on the assignment. But if I may to add some comments on what both Michael and Fatma have said, the first element, and that's from my perspective as employment lawyer, important one, that is the comment that Fatma made on the team. And I noted that she said, well, make sure that within the team you have some decision authority, which is of course important. But a very crucial footnote there is that if you look to the timeline of an investigation, ultimately it leads to a report, and based on the report, someone has to take a decision and can come down to a disciplinary action against certain individuals. And then we have some legal timings, like if the person involved, the suspect, is an employee, and you would like at the end of the process to dismiss that person for cause, for a serious cause, then you have that famous very short deadline of 3 working days, starting on the day that someone, and that someone is the person authorized, competent to make someone redundant, is get knowledge of all the facts. And for that reason, we always advise the client, of course, to make a team that can take decisions and can move forward. But the ultimate decision maker, the one who is authorized to take the disciplinary decision, can be an HR person or can be someone from the board or whoever, but he should not be member of the team and even not involved in the investigation, to avoid the argument from the counterparty that, yeah, the company and the person who was competent to make that decision already knew all the facts long time before, and so you are in violation of the 3 days deadline. So that's, I know what you meant, Fatma, with pointing out that the team should be authorized or have authority, but that's something to keep in mind, and make sure that that final decision maker is not part from the beginning of your team. And when you have internal reportings, we all know that probably it goes also a little bit in a confidential way, and that is of course some internal discussion about what's going on, but the formal reporting line to the board of directors or the HR manager is at the right moment. That is after the report is complete and is then submitted to that person. A second comment is on what Michael explained on the channels through which you get informed of fraud or irregularities, is that the whistleblowing line. In my experience, is that especially larger companies, they have whistleblowing procedures, but they are not so successful. Most of the investigations I've been involved in started with the informal complaint or allegation, which Michael referred to. Probably that is because under Belgian law, we do not have a strict legal framework on whistleblowing. There are some industry sectors for which there is a legal structure available, like financial institutions, or in the insurance industry, there is a strict legal framework also for the public sector, for federal civil servants and so on. But in the private industry, there is currently no obligation to have such a whistleblowing line. I believe that the whistleblowing directive may be a game changer, because this directive will have to be implemented also in Belgium before the end of the year, will impose an obligation to have such a whistleblowing reporting tool. And the scope of application, although linked to European law, is rather broad, because it covers all EU law in a very broad notion. It also applies to not only civil servants, but also employees, self-employed individuals, board members, and so on. And this will probably trigger a wave of more whistleblowing hotlines implemented in companies. 2 comments from my side. First of all, the scope for your whistleblowing hotline. Exclude all procedures which relate to bullying and moral harassment. We have a very good working and mandatory legal process in that respect, which is governed by the health and prevention advisor in the company. So there we have a legal framework. We see a lot of complaints coming, as Michael, I think, also mentioned, based on sexual harassment. But we have a legal framework already in place for years in Belgium, which is very good regulated. And so exclude explicitly all elements already covered by other legal processes from your whistleblowing hotline. And second comment in that respect is that the directive also provides or requires that the member state must take necessary measures to prohibit any form of retaliation against a whistleblower. Under Belgian law, probably this will take the form of a protection against dismissal, meaning that someone who files notification at the whistleblowing hotline by notifying becomes protected against dismissal. And if he can prove that the dismissal is based on the fact that he notified something at the whistleblowing hotline, that he may not be dismissed, and that there will be a financial sanction. Often it is capped at 6 months salary and benefits. Under Belgian law, reinstatement is never a sanction there. So someone who is dismissed will never be able to claim reinstatement in the company, but there will be financial compensations linked to that. And that means that, again, that there will be probably, or there might be some room for abuse, because someone who fears to be on the list to be dismissed can try to get extra compensation, extra protection by filing a whistleblowing complaint. And so your process to select what complaint is credible and which is not credible is very important, that from the beginning you can make that triage, so to say, that you can make that distinction between well-founded and obviously not reliable complaints in order to prevent people from getting a protection against dismissal. So these were a few, let's say, out of my head comments to what has been said by the two other speakers until now.
Thanks a lot, Jan. It's actually you that we move to for the next.
Joe, I know that time is limited, but there are all quite a lot of questions in the chat box.
Yeah, okay,
I don't know when you want to address them. Let's
give those a bit of. Do you want to? Because I see that you've answered a couple of them. So do you want to expand on those answers, or did you want to?
I think with the limited time, I just see that there are really interesting questions, but most of them require really a separate seminar. If it's about preserving evidence, how do you get the right people around the table? But it just shows, I think, it shows really that a lot of in-house counsels are really confronted with these issues and have like still adamant important questions around process, how to do it. And it's actually so case by case specific. I think the only thing, the questions that I could answer was more like colleagues that talked about culture, and culture is not something that you create in a day. It's a very difficult one. But what I really saw in companies, the companies that really focused on that speak up culture and led by example, and taking it serious, it's not just lip service to speak up service. There are really saw culture changes. We're taking also the compliance function very serious, making that a powerful position. Plus also, if you even have rock star employees with the best numbers, but we really like not so ethical behavior to really take decisions. So that's really a short response, of course. And another question, what I thought interesting was, what do you do with social media impacting how a company handles communications? And our colleagues in the retail sector will know it's very different B2B and then in B2C. In a B2C environment, you can have the perfect investigation plan and a communication plan, and the moment that there is a leak out, that you have to change it quite completely, quite drastically. So the ones that are on B2B are a bit have more time and for that, and do not have to react immediately. So
yes, if I may add, this is Yves speaking. That's a very important element, which I also refer to when to opt for civil or criminal action, is publicity. And if you form the team, as Fatma hinted, please also contact the communication manager in-house or external, because that is crucial. And in many cases, they are even on board before we, as important outside counsel, are on board, because that's and there should be an interaction between legal and communication for several reasons, strictly legal reasons. But you should have a Q&A. You should have people appointed who to go to. No comment, please contact XYZ. And indeed, that's a very important role from my perspective, to take into consideration. And it is forgotten a lot, and it might determine the strategy, also the legal strategy, which I'll talk about later shortly.
Thanks a lot, Yves. Yeah, okay. Well, let's move on to the third topic now that we've answered a couple of those questions. So yeah, that's Jan, I believe, conducting the investigation. So the meat, real meat.
The real meat. Okay. Well, I have only 10 or 15 minutes for this. So a few, let's say, comments from my side on how to conduct the investigation process. First of all, a question we always get is, do we have to report the allegations or the suspicions that we have to public authorities? The answer is no, as a general rule. At least is no for private sector companies. There is an obligation to disclose criminal offenses for public entities, public officers, civil servants, if they become aware of criminal offenses in the performance of their job, but this does not apply in general to private companies. So you can perfectly decide to organize your own internal investigation within the company without involving the prosecutor or the investigating judge. A second general comment has already been touched upon, I think, by Michael, is, but very important, at least in Belgium, is the language. Because especially when employees are involved, any document that is that relates to the employment relationship and that is not in the right language might be null and void and not enforceable, especially in the Dutch-speaking part of Belgium. Very strict and serious sanction. So if you have interviews or documents exchange or emails that you send to employees during the investigation, make sure that you use the right language. And a third general comment is on garden leave, because it's always also a question that comes up even especially at the beginning of the investigation, where they say, well, we have suspicions against a certain person. Can we ask him during the investigation to stay at home, not to show up, not to work? Can we refuse him access to emails or to our systems and so on? And there the clear answer is this is only possible with the explicit consent and approval of the person involved, at least when it is an employee of your company. If you would do that unilaterally, it might be considered as what we call a constructive dismissal. And if he's smart, he will immediately after getting an email from you saying you are not allowed to access the building anymore and your email has been blocked and so on, send you an email saying, thank you very much. I consider this as dismissal, as a termination of my employment contract, and I claim the full legal compensation resulting from that termination. And that's precisely what you want to avoid. So try to make, that's an annoying thing if you compare to other countries. Most of the countries that I've experienced with, they have a kind of arrangement to send someone home unilaterally in such a case, but in Belgium this is not possible. Then, yeah, when we come to the investigation process itself, we see there typically a number of steps in the investigation, and the time is too short to go into every detail of every step. But in general, first step we already discussed is to determine the scope and approach of your investigation. Very important to identify which data and which irregularities you are going to investigate, make an overview of all the persons that are potentially involved in the situations, their interrelations, and determine the method, tools that you will use to collect the evidence, because that's the most crucial element in the context of the investigation, is to make sure that the evidence that you collect can be used afterwards in a potential disciplinary action or in a litigation that might happen afterwards. Second step is think about how to preserve and secure evidence. Even before anyone is informed of the investigation, it is important that you think about, is there some documentation or are there some data that are stored at a certain place which I need to secure before even starting off with the investigation. And in that context, my experience is that it is often useful to involve IT specialists, forensic specialists, who have a number of tools to make sure that they take a secured copy of like a hard disk or a mailbox, even without accessing the mailbox, without screening it, but having at least a secured copy that you can say, well, at that point in time, there was a mailbox with this data in it when it would be necessary to use that mailbox. The most typical action in the first instance is the interviews with several persons involved. There is no strict legal framework on how to conduct an interview with people, can be witnesses, can be suspects. The basic rule, and that applies to the entire investigation, is that the investigation should be reasonable in all circumstances, which means that the investigation should be fair, balanced, and thorough. And these are the three guiding principles that you and the investigating team also should keep in mind. The investigation must be fair, balanced, and thorough, and every step you take should comply with these goals. And when it comes to the interviews, this means that what we always recommend to the clients is use the same approach as the federal police uses when they have an interview. They always read you before starting the interview your rights, so to say. And if you look to that set of rights that are applicable to the interviews from the police, it's always good to apply the same in your case. And this implies from the beginning that you inform the interview of a number of things, like the fact that the interviewee may be assisted by a legal counsel or a person of trust. For employees, this means that they have even the legal right to be assisted by someone from the trade union delegation if they request so. Confirm before starting the interview that all questions and answers will be noted down in the report in his or her words, her own words, and that he or she will have the right after to read the report and to make comments and changes where necessary. That the interviewee can always ask for specific or additional investigations to be carried out. It's always good to mention the basic right that we all have under Belgian criminal law, that you cannot be obliged to self-incriminate yourself, to make statements which compromise yourself and incriminate yourself. That the person can use supporting documents to during the interview. And as I mentioned, that the person can revise, complete, and correct the interview. We always recommend to have at least two investigators present during an interview, and someone to take notes, and that at the end, as I said, the notes are signed off by the person that is interviewed, and that they are ultimately attached as an addendum to the investigation report. A second step in the investigation is, or a second method of collecting evidence is typically searching a mailbox or a hard disk or other, let's say, privacy sensitive action. And as Fatma already mentioned rightfully, it is important to have a data protection specialist around the table from the beginning in the team, because this is often the line of defense of someone who is sanctioned afterwards, to say, well, you did not respect the privacy rules when collecting certain data, and that means that this data cannot be used against me in a litigation. It would go too far to expand now on all privacy issues, but just to remind you the basic rule, but which is still a very important rule and sometimes often not respected, but that is that there are three conditions to do a, let's say, search of a mailbox or another investigation method to be compliant with privacy law. First of all, make sure you have a legitimate purpose, and discovering fraud or investigating irregularities is certainly such a legitimate purpose, provided that you can prove that when you started your action, that or your investigation, that you already had some objective elements pointing in the direction of a potential fraud. That doesn't mean, of course, that you need to have all the evidence, but there should be sufficient ground for having suspicions to start an action like screening a mailbox or something else. And it is also recommended to include in the report, because the drafting of report, I see a lot of mistakes often there in the report, and they come out when you have to use the report in litigation. The report should be very precise and also mention the context, why and when, and at the request of whom the investigation started, because these are typically questions that are asked by a judge or by the lawyer of a counterparty to challenge the report. And if it's already clear from the outset in the report that based on a number of facts, like a whistleblowing notification or other elements, or an email that you received from a client or whatever, that was the starting point of the investigation, this will allow all the parties afterwards to check the chronology and to make sure that everything went within a reasonable time frame and according to timings that are legally imposed. Second element, so the purpose. Second is that you need to have the, let's say, informed consent, the transparency with regard to the persons involved to make to access a mailbox, and that informed consent and that transparency is linked to the existence of an IT policy. And this is often the first document, not often, always one of the first documents that we ask for clients is, do you have at least an IT policy which provides for the possibility of applying certain investigation methods, which outline the conditions and so on. If so, we are at ease and we can start off. If there is no such a policy, this will restrict us to a large extent in what we can do as investigation actions without running the risk of getting evidence that would be rejected afterwards in a court litigation. And the third element is that your action should always be proportionate to the goal that you try to achieve, meaning that the intrusion in privacy should be limited to the minimum possible. And that means that phishing expeditions on a mailbox, they are not allowed. If you do a search on a mailbox, do it on the basis of search words, selected words that are related, of course, to the allegation or to the irregularity, and include also in the report, or ask your external forensic partner who drafts the report to mention explicitly that list of words that has been used, so that the judge afterward can indeed also assess and value that that you did not simply read every email in the mailbox, but that you looked for only relevant data and content in that mailbox. And when respecting these elements, I believe that there is no problem. In practice, we see that there is no problem in using evidence in a court litigation afterwards, even based on a mailbox that has been screened. So the fear from some clients, they have, no, let's not touch a mailbox because that is very dangerous. I do not share that view. You can perfectly organize in a way that you can use that evidence. And the most useful evidence that I see in investigation, coming out of an investigation, is exactly that. That is the mailbox. I'm looking to my watch, so I have still 1 or 2 minutes left. I had a number of things still on my list, but let's say that at the end of the process, there will be an investigation report. Often you also will, or you may also yourself draft report, and what is in the report crucial is that it is factual, that it contains facts which are mentioned in a precise and impartial way, but very precise facts. No conclusions, no qualifications. It is not up to the investigators to qualify the facts, to say, well, this has happened and this is embezzlement, or this is whatever it might be. This is fraud. That conclusion is not up to the investigators. That is ultimately to be drawn by the competent body to make a decision on disciplinary actions and a judge, but keep it very factual to avoid the criticism that the report is not impartial. Voilà. These were some, let's say, loose comments on the investigation. I've seen in the on the chat that there are more questions in that respect, so I'm open to answer them later on.
Yeah, maybe we'll do some questions at the end. But just because I'm conscious of the time, I think maybe we'll go on to even the final topic, and then we'll do some of these questions at the end for whoever feels most qualified to answer.
Yes, thank you, Joe. A webinar like this is like an internal investigation. You have to be agile and adapt to circumstances in this time, the time a little bit. What I wanted to talk about is basically what next. And obviously the next steps are related and should be taken into account as from the beginning. Namely, when do you end the relationship? I call it with wrongdoer. Jan touched on it, that you have sometimes particular cases, like indeed with employment contract. If you want to terminate for serious schools, you have the three days rule. The same goes for commercial agents, because your external partners or one of your partners might be involved. There you have the 7 days working days rule, also for terminating for serious breach. During the investigation, there should be a goal also in that perspective. What is the ultimate goal of your company? Is it the primary goal for asset recovery, for the damages repair? Is it the goal to restore, let's say, ethics within the undertaking, or indeed terminate as quickly as possible the relationship? And that are, let's say, 3 points that comes in many cases into the balance to decide what to do. Employment contract, commercial agency contract, and then in general, when can I terminate my contract? Because you will try to terminate a contract sometimes too quickly when you see, based on the report, some possible fraudulent actions, which in your mindset is fraudulent, and in the mindset of the company and the decision makers is fraudulent. Please check first the contract before taking indeed actions and sending out a termination letter to see what happened. For example, I had experience that a contract provides for a possibility to immediately terminate a contract in the event of a conviction because of bid rigging. And there was an internal investigation pointing at that. What has terminated the contract quite quickly after they completed the report, but then it is contested because the contract specifically stated that termination is also only possible in the event of a conviction, and then the wrongdoer will rely on obviously the presumption of innocence, etc. Because before a commercial court, fraud is difficult to prove, and one assumes good faith. So then obviously you fall back on the quality of your report and the facts there too, to evidence, as Jan said, that fraud. And it's not because the investigators says it is fraud that it is fraud before a judge. So that's, I think it's an important element to keep in mind. Check the contract before terminating. Obviously, you can terminate based on Belgian Civil Code. Everybody knows that. You don't have to go, let's say, into court or file for first submitted notice of default, etc. But I think that element should be included in the plan you draw up when conducting an investigation, the different steps, and you can link there also for your lawyers, which we do, the fee quotes relating to each milestone or step. But that aspect should be included in that plan, that approach that you, let's say, would agree. And obviously, that can change over time and should be detailed over time. A further element in the same line is that breach of contract. Jan mentioned already the IT policy. Sometimes you see that you have also obviously other policy of good conduct and policy on costs, etc. within the company. It's good to have that because and to include the sanctions for a breach of that policy, that will help you for the further sanctions in or termination of contract, also toward outside service providers. Bear in mind, false independency, do not just submit your employee policy to your service providers. That is handled as, let's say, general conditions should be communicated and agreed upon contracting to invoke a breach of policy towards your service provider. A third element I wanted to stress is damages. If that's a focus of the company, so to recover damages, it should also indeed be a point of attention in your report, and that should be based indeed on actual underlying documents that can link the damages and prove the damages. Because I had a case where indeed there was a termination of a contract whereby the wrongdoer said, okay, I will repay, and I admit there were irregularities, etc. And at that stage, there were false invoices discovered of around 100,000 euros. But then it appears that there were several other breaches which were not, let's say, submitted to the, at that time, former employee. Long story short, insurers pays over 1 million euros to the insured because of a fraud policy. And now we do the subrogation claim where we obtained a judgment in first degree. We will appeal that, where the court says, okay, your report which is made basically on damages by the insurer, is not opposable, cannot be used, and only 100,000 euro damages were granted. Obviously, there was also in this particular case 6 years between the event and the recovery, and now so you need to have, as Jan also said, the precise facts, and everything should be added as an annex to the report. If you have just analysis of some invoices, please include those invoices as an annex, so you have that evidence, and you can have later a contradictory debate, as we call it, in front of a court. But basically, based on even an outside report from a reputable outside forensic firm, will not be, let's say, the holy grail in litigation. So also there, please have that in mind if that's one of the indeed elements the company wants to pursue. Bearing time in mind, just pointing out conservatory measures, there also you have a conflict on when you will go to a conservatory attachment. So bank account freeze, real estate attachment, because if you do that, you basically say as a company, we know that you have done wrong. We have a claim on you because that's one of the conditions for an attachment, a claim, a payable and due claim. But if you then terminate the contract only 1 month later, for example, you have an issue to say that was a serious breach at that time, which makes any further cooperation difficult or impossible because you knew it already 1 month in advance. So you have to think about that on conservatory attachments and the timing thereof. The asset tracing. Know that in Belgium, for example, real estate, you can do that, but it takes time. It takes even up to two months to obtain the information from the land register and mortgage office to have the documents that you need to go to do a conservatory attachment. Think about movable assets, low value, high impact is also my credo there. But there, the time is essential. Say for third-party attachments, you have to go to court. The court has 8 days to grant you permission to attach. Sometimes it's 1 day, but you have to call or the lawyer has to call the judge to make arrangements on that and see what's possible to have that all aligned. Sometimes you have multiple jurisdictions within Belgium that are competent to grant permission. So that should be lined up. And there again, indeed, the report will be a proof of the due and payable claim. Then going forward, yes, I just mentioned the European bank account freezing regulation of 2017. It makes it more useful or practical to also freeze bank accounts abroad based on a Belgian permission to freeze from a Belgian seizure judge. You can also request basically from the authorities abroad the numbers, the bank account numbers of your debtor. Okay, it's quite new, not really used a lot today. And even there are plans that you can now find out in Belgium the bank accounts of your debtor. But that system is also not yet in place, so that's the future. That's a kind of a fishing expedition to see where you can find what money to recover. Also shares, etc. Everything is basically seizable in Belgium, but you have to find it, and that's not always easy. But there are some searches on public databases might help. I had also, to round up Joe and everybody, self-disclosure to enforcement authorities. Jan tackled that point. And then finally, yes, always a question, criminal complaint, and bring your civil action before the criminal court, or we keep it pure civil. One important element that we discussed earlier is publicity. If it goes criminal, although it's typically not public criminal investigation, that might leak in the press. criminal complaint, you have a kind of loss of control over the process as such. You really give it in the hands of the public prosecutor's office and the investigating magistrate if you file also a constitutional civil party. I think we had very good experiences with most investigations, but they tend to take some time. But the pro is that you will find more about the truth, so to say, and you can trace more assets in principle. So that's really depending also on the wishes and the culture of the company. That should be decided in that view whether you want to do that or not, and also depend certainly on the quality and the evidence you find in the report because of the reasons I indicated before. But in any event, it's good to prepare for a visit from the authorities next to the antitrust authorities and DPA. Prepare for a visit because I filed a complaint and 2 days later there was a search in the offices of my clients. So the victims, so to speak, they were not prepared. Or they were surprised, obviously, but that was indeed for preserving evidence and they took a copy of some certain documents and from the server, etc., so that if it is in the framework of a search, that evidence is, let's say, as solid as a rock, so to speak. So we have a one-pager if we believe it's coming up with the basic things to do, put people in a room, etc., etc. Call your lawyer is one of those also that we, let's say, give the clients for internal use. I think we are in time, so I would like to indeed, I think, stop my intervention here. I highlighted the most important points, but to round up, I think that also those elements is essential from my point of view to include in your internal investigation plan from the outset. So we know, although it's, let's say, you make a plan from A to B with one line, but it will, let's say, meander alongside the journey, so to speak. But that those goals also kept in mind, because if you're thinking about that too late, it might be too late to avoid problems with that. So that's what I wanted to add from my side.
Thanks a lot, Yves. I think we'll do one question, and then we might have to wrap things up because we are running out of time a little bit. But what are some of the red flags that would prompt an investigation? And what should in-house counsel look out for? So that I think any of you can answer that one probably.
My mic is still on. 2 points. Typically, as Jan indicated, it's forensic accounting with the accounting. And secondly, which is very important, and I think that should be monitored, that there are some, and from my side, commercial agreements and contracts, that there are some very privileged partners that you see in a company, that you hear the buzz to say, okay, we have 5 possible partners, and there is one Eve or John or Joe Doe or Jew that is really a friend of the firm or a friend of the company. And that's what I see with my bid rigging example. Upon interviews, was always, if he calls, he was treated as a king, while basically he was only a supplier. To keep that in mind, basically.
Thanks a lot. All right. Well, unless anyone has anything to add, I think we can wrap things up there. So I suppose all that's left to say is this has been a Legal 500 webinar sponsored by Lydian. Thank you all for watching, and also thank you to our fantastic speakers.